Cohabitation and alimony in Florida.
Almost every Florida divorce has the possibility of an alimony award from one spouse to the other. In a proceeding for dissolution of marriage, the court may grant alimony to either party. Florida. Stat. Sec. 61.081. Alimony is awarded in a Florida divorce. If the court finds that a party has a need for alimony or maintenance and that the other party has the ability to pay alimony or maintenance. Florida. Stat. Sec.
61.082.
If the ex-spouse receiving alimony moves in with a boyfriend, girlfriend or gets remarried, the presumption is that the new partner is now supporting the ex-spouse. So the old ex-spouse is automatically relieved of their obligation to pay alimony. This is not the case under Florida law. Cohabitation is a basis for modifying alimony after a Florida divorce. Florida's statutes and case law allow for a modification of alimony if the alimony receiving ex-spouse is cohabitating with someone. In lieu of relying strictly on cohabitation, Florida law investigates the broader concept of a supportive relationship. The court may reduce or terminate an award of alimony upon specific written findings by the court that since the granting of a divorce and the award of alimony, a supportive relationship has existed between the obligee and a person with whom the obligee resides. Florida. Stat. Sec. 61.141(b). The burden to prove a supportive relationship rests with the person trying to reduce or terminate alimony, the alimony payer. On the issue of whether alimony should be reduced or terminated under this paragraph, the burden is on the obliger to prove by a preponderance of the evidence that a supportive relationship exists. Florida. Stat. Sec. 61.141(b). Preponderance of the evidence is the greater weight of the evidence, not necessarily established by the greater number of witnesses testifying to a fact but by evidence that has most convincing force. Superior evidentiary weight that, though not sufficient to free the mind wholly from all reasonable doubt, is still sufficient to incline a fair and impartial mind to one side of the issue rather than the other. Black's Law Dictionary, 11th ed., 2019. Proving a supportive relationship can require any kind of evidence. Photos of a car outside a house night after night, credit card receipts showing expenses that have and have not been paid, and/or the deposition of the new partner. The Florida statute lays out 11 factors that a court can consider to establish if a supportive relationship exists. In determining whether an existing award of alimony should be reduced or terminated because an alleged supportive relationship between an obligee and a person who is not related by consanguinity or affinity and with whom the obligee resides, the court shall elicit the nature and extent of the relationship in question. The court shall give consideration, without limitation, to circumstances, including, but not limited to, the following, in determining the relationship of an obligee to another person. A. The extent to which the obligee and the other person have held themselves out as a married couple by engaging in conduct such as using the same last name, using a common mailing address, referring to each other in terms such as, my husband, or my wife, or otherwise conducting themselves in a manner that evidences a permanent supportive relationship. B. The period of time that the obligee has resided with the other person in a permanent place of abode. C. The extent to which the obligee and the other person have pooled their assets or income or otherwise exhibited financial interdependence. D. The extent to which the obligee or the other person has supported the other, in whole or in part. E. The extent to which the obligee or the other person has performed valuable services for the other. F. The extent to which the obligee or the other person has performed valuable services for the other's company or employer. G. Whether the obligee and the other person have worked together to create or enhance anything of value. H. Whether the obligee and the other person have jointly contributed to the purchase of any real or personal property. I. Evidence in support of a claim that the obligee and the other person have an express agreement regarding property sharing or support. J. Evidence in support of a claim that the obligee and the other person have an implied agreement regarding property sharing or support. K. Whether the obligee and the other person have provided support to the children of one another, regardless of any legal duty to do so. Florida. Stat. Sec.61.14, 2. Proving a supportive relationship is a loosey-goosey concept that, fundamentally, only requires proving some kind of change. Although the supportive relationship concept is specifically defined by statute, it is in essence a substantial change in circumstances. Bowman v. Bowman, 22.3d 719 Florida. Dist. Court of Appeals, 2nd Dist. .2009. The standard of a change in circumstances is that simple. Alimony can be modified if the circumstances or the financial ability of either party changes. Florida. Stat. Sec.61.14, 1a. To obtain a modification under Section 61.14, 1a, the trial court must make a determination that 1. There was a substantial change in circumstances. 2. The change was not contemplated at the time of the final judgment of dissolution. And 3. The change is sufficient, material, involuntary, and permanent in nature. Murphy v. Murphy, 201.3d 18 Florida. Dist. Court of Appeals, 3rd Dist. .2013. If the change in circumstances is cohabitation, an even simpler equation is considered. To find a sufficient change in circumstances to warrant a reduction or the termination of alimony based on cohabitation, a trial court is required to consider whether either of the following two factors is present. 1. Whether the cohabitant provides support to the recipient spouse.
Or 2. Whether the recipient spouse contributes to the support of the cohabitant.
Murphy v. Murphy, 201 So. 3d 18 Florida. Dist. Court of Appeals, 3rd Dist. 2013. Every modification of alimony goes to a full hearing. After all, what does the cohabitating alimony receiving spouse have to lose? So, be prepared to investigate and argue whether cohabitation exists and to what extent the new roommate, boyfriend, girlfriend, spouse pays towards this new relationship. To discuss modifying alimony due to cohabitation, contact my Naples, Florida family law firm to speak with an experienced Florida divorce attorney.